contentos de contar con la presencia de Anthony Perri, quien es abogado cum laude por la Universidad de Fordham y maestro en Derecho en la Universidad de Notre Dame. Ha sido letrado en la Judicatura en el Distrito Este de Nueva York. Ha sido asesor de víctimas y asesor del fiscal de distrito de la Oficina de Víctimas Especiales del Condado de Nassau. Actualmente se desempeña como viceconsejero de Justicia Penal en la Oficina de Administración del Sistema Unificado de Cortes de Nueva York, o New York State Unified Court System Office of Court Administration, OCA. Y durante la emergencia de esta pandemia ha sido asesor de varios comités y grupos de trabajo de la OCA para los procedimientos judiciales virtuales y el restablecimiento de las operaciones de justicia en línea. Bienvenido, muchísimas gracias, Deputy Counsel Anthony Perri.
Good morning, Laura. Thank you, everyone, for inviting me to share some of the time here today. And on behalf of Judge Marks and Judge DiFiore, the Chief Judge of New York, thank you for including us in this panel today. And that I'm very happy to talk about how the New York State court system has tried to leverage technology and its various other data resources, specifically in response to the COVID-19 public health emergency, that really forced us as a justice system to go beyond what anyone had previously probably imagined we would be capable of to ensure the continuous access to the courts throughout the pandemic. Now, the state court system of New York handles nearly 4 million cases a year, heard throughout 62 counties, 13 judicial districts, 4 appellate divisions, and the Court of Appeals, our supreme, our top court in the state. And COVID-19 presented for us an extraordinary, truly unprecedented challenge for judges, non-judicial personnel, for the state, and that it required an entire reimagining of our procedures, really focusing on how we are going to, when we cannot be physically in person together, how are we going to ensure justice continues? And that never before in the United States, state or federal level, have we ever seen such a far-reaching, prolonged emergency that caused complete disruption of our normal operations and required us to evolve quickly, not just for our own sake and for the litigants, for the judges, for the court personnel, but really for the greater community, not simply for the access to justice, but as the courthouses were these centers of civic life that brought people together, where now that suddenly became so dangerous. In pre-pandemic times, hundreds, if not thousands of people passed through and gathered inside of New York's courthouses, especially inside the city and in the densely populated other cities outside of New York City itself around our state. We worked in an environment where there were calendar calls, where dozens upon dozens of cases were set for the same time for in-person appearances by the litigants, by the attorneys, where you'd have oral arguments morning, afternoon, and nighttime, 24-hour a day, arraignments, bringing newly arrested defendants into court before a neutral magistrate, evidentiary hearings, grand jury proceedings, and trials were all presumed to be practically 100% in-person events with very little use of technology for the actual working out of proceedings and the provision of justice on a daily basis, where, especially in the city of New York, courtrooms would often be operating at capacity for significant portions of each working day. And so that COVID-19 truly required us to use technology really for the first time to combat the limitations. So that once the true horrific extent of the virus became evident in New York, where we really did face the brunt of it at the start in the United States, at least, the governor of New York State declared a state of emergency within New York State, and then the chief judge and the chief administrative judge made the difficult decisions that although the courts would remain open, to remain open in some capacity to handle all essential matters, everything else had to be postponed. But the manner in which we were going to handle those essential, most critical aspects of justice that often touched upon the lives of the most marginalized in society, that the manner in which we were able to do that demanded a complete revolution in how the courts in New York State interacted with technology. And so since that initial emergency order from our governor and then various administrative orders from our chief administrative judge and chief judge of the state, New York then created a virtual court system entirely within weeks of the pandemic arriving. That was especially focused from my work on criminal proceedings and ensuring that there was not going to be a disruption of criminal proceedings, especially where the due process rights of defendants would be jeopardized. So the first step in doing that really was in the creation of virtual arraignments, and that the arraignments were the first step of a defendant being brought before the court after their arrest. That we're literally talking about thousands of cases in a given day across the state. And that for the first time on any large scale, judges, defendants, prosecutors, defense counsel ensuring representation at that initial appearance were all brought together through video conferencing technology. Documents were being exchanged virtually in electronic format for the first time. And that we were striving through this upgrade, first taking place in New York City and then replicated throughout New York State, to ensure that we were able to abide by the human rights, the constitutional and civil rights of defendants, and ensure that cases progressed forward despite the emergency, and that those defendants that should be released pending actual adjudication of their guilt or innocence was achieved in as timely a manner as possible. And that once up and running, even though everyone was remote once the pandemic was at its height, we were able to abide almost throughout the entire pandemic to a rule of 24 hours from arrest to being before a judge. And having that judge hear the initial accusations, reviewing the documents substantiating the arrest, and then making a decision with respect to custody. And that really was revolutionary for New York to achieve in such a short time frame. And similarly, there was a real concern with access for these proceedings, not even though they had moved into a virtual space and were using technology, that the access by the public to these proceedings and the ability to have these proceedings be visible and not secretive for the members of a defendant's family, for interested parties, for the press, for prosecutors, and for offices, victims, to see that how justice was being carried out and continuous was a difficulty. That normally under New York state law, criminal proceedings are not broadcast. But because of the emergency, there was an adaptation that had to take place there, whereby first they were being broadcast inside courthouse facilities where social distancing and other safety protocols could allow for the ability to see the proceedings. But then as our understanding had to evolve, so the decision to allow links to broadcast to specifically interested parties, any and all court proceedings were established during the pandemic. And similarly across the state, in our family courts, in our civil and criminal supreme, inferior courts, and even in our appellate courts, we replicated what we learned in the criminal courts in this first steps to eventually expand virtual courts to all matters of cases. And this included at the start those essential, most important hearings for family offense petitions, child abuse and neglect matters, especially those involving emergency removals of children from unsafe situations, juvenile delinquency petitions, emergency housing court matters, and those habeas challenges to wrongful incarcerations of prisoners and other emergency medical decisions, all were moved from an in-person presumption to being on a virtual platform. And when we look at especially evidentiary hearings, that brought with it a host of challenges and problems that had to be overcome by the courts of having evidence securely transmitted back and forth and ensuring that all parties were privy to the same information. And the courts had to create and secure pathways for the uploading and sharing and admission into evidence of all of these documents, videos, and other footage. And for when testimony was being received in preliminary hearings in criminal matters, that to protect victims, especially of when we're looking at domestic violence cases and other crimes of a sexual nature, that victims' identities could be protected while at the same time allowing a judge to be able to view them, to be able to ascertain and assess their credibility as they are testifying, and yet protect them from public view and or being confronted at early stage of the case with their alleged abuser and who had, in some cases had recently victimized them. And so the courts had to work for the first time to have the technological capability to allow the conferencing, the video conferencing to take place, to have a platform that was readily accessible to parties that are not part of as collaborative a system in the adversarial common law system in the United States, so that prosecutors, defense counsel, the defendants who may at times be held in custody, all could be on the same platform, and yet it is regulated, controlled by the clerks and by the judges in the courthouse to ensure the fairness of the proceedings and the stability of the platform to weather the unanticipated events that happen in any kind of a live proceeding with witnesses. But this became even more critical in New York because we are, as a common law jurisdiction, also a grand jury jurisdiction where any individual arrested on a serious felony charge is required under our Constitution to have that case presented to a grand jury of 23 randomly selected members of the public to vote on whether that case can go forward, to be presented with preliminary live, non-hearsay evidence of civilian and law enforcement witnesses. And that during the pandemic just was not possible. And so what the chief judge and the chief administrative judge had to work to create were the reinstitution of other preliminary hearings to ensure that due process rights before a judge could be protected through a digital format, through virtual proceedings, to stand in the place for that, to make sure that individuals were not being held pending further proceedings and a grand jury determination of whether their case had probable cause to go forward without that level of due process being ensured. New York State has traditionally had a resistance to electronic filings and to virtual technology, especially in the criminal context. And I can understand that there is, and the courts are aware of, there are advantages to all of these instruments and to these means, but there are dangers of the dehumanization of the defendant, of appearing virtually, of them not having simultaneous confidential communication with their attorney, their counsel, and that these issues have to be accommodated by any digital platforms that we are working with, and that we have selected and used means of technology that have the defendant and their counsel able to have separate audio conversations while still participating in the live video. At the same time, we also have utilized platforms that allow for the use of breakout rooms, of exchanges of data between parties within a larger proceeding. And we have worked with our technology officers to create platforms that replicate the appearance of an actual court proceeding, because we have also found that the move to a digital format and to the virtual space does run the danger of not affording the substantial similarity of an atmosphere that is utilized in the adversarial process have a fair playing field for the parties to litigate their issues. And so that going forward, however, as the metrics have subsided, the courts are hoping in New York State to have what are a lot of these emergency measures that were done in conjunction with our governor's office and others instituted into law to allow and to regulate where it is appropriate to have virtual appearances, electronic appearances that allow a greater access to justice to individuals in a more efficient manner, with less interruption to their lives and less need to appear in a courthouse that sometimes can be many miles from where they live. And at the same time, ensure that where a defendant and or their counsel wish to appear in person and want to be before that judge for good reason and do not believe the digital virtual format is appropriate for a sensitive proceeding, they have a right to object, they have a right to demand to be produced, and that especially once we are emerging from the pandemic in normal times, those due process rights and those human rights are more appropriately protected in person before a judge and with full confrontation for whatever charges and evidence is being presented against that defendant. And so that the nuances of how technology affects witness testimony, defense appearances, consultation between defense attorney and their client, a judge's interaction between attorneys, especially in the criminal context, is something that we are working through on a daily basis. And that thankfully we have amazing judges that have been willing to make those determinations on a case-by-case basis of where, in certain circumstances, the greater good for the defendant and for the community at large is served by proceeding forward virtually, where at other moments caution causes us to take a pause and to ensure that there is proper informed consent for some forms of proceedings, and that the level of technology is of such a caliber and the internet connections and the access is of a high enough level to allow for the proceedings to have an integrity that will allow them to fulfill the obligations of the courts to be doing justice at all times and not just focus on efficiencies and expediencies, but of a higher calling that ensures due process is protected for all parties, not just in a criminal context, but also in a civil context. And just even in the first presentation, the going forward need to ensure that the data that is being collected and being reviewed by the institutional courts, by the parties exchanging information and evidence throughout proceedings is protected, is also one of the highest needs that the court system is addressing, and has, through creating platforms that allow for secure upload and review of evidence and data by the judges and the clerks, has been one of the major steps forward. And so that what the chief judge and what the chief administrative judge hope for our court system is that in emerging from the emergency pandemic that has allowed for an amazing amount of innovation to confront the tragedy that really did grip our state and allowed for the courts to stay operational and accessible, we don't want to go back to there is no going back to what existed before. That while aware of the challenges that technology raises, and what the courts do not want to do is to lose the gains we have made and to allow us to learn and codify into permanent legal reforms with our partners in the legislature and the governor's office, procedural changes that rather than fully being as restrictive of the use of technology in proceedings and virtual court appearances, regulate it and ensure that the rights of all parties, defendants, the government and prosecutors, the victims of crimes are protected properly, but that we maximize the good that this technology can bring in bringing greater efficiencies and greater justice to the entire state. Thank you again for inviting us, and I would be happy to entertain any questions at the appropriate time. Thank you.
Thank you so much, Anthony Perri. Thank you for remembering us. Muchísimas gracias por compartirnos su experiencia sobre las grandes dificultades y resistencias que pareciera, que hay muchos adelantos, ¿no? Las audiencias por teléfono, muchas cosas que aún así, pues que aún así han resultado una dificultad y que usted nos los está comentando. Y bueno, sobre todo principalmente en la materia penal, en audiencias en las que se desahogan pruebas testimoniales y bueno, las dificultades que esto ha implicado, las dificultades normativas de procedimientos, especialmente en relación con el debido proceso, como nos comenta, de implementar mecanismos de justicia digital cuando las leyes o procedimientos no fueron pensados o no eran pensados para ser digitales, sino virtual, bueno, para ser en persona, en papel. Y bueno, nos gustaría quedarnos antes de regresar con las preguntas con usted. Muchísimas gracias con una frase que dijo: no hay vuelta atrás, estos cambios procesales y virtuales llegaron para quedarse. Entonces, esperemos que así sea y de la manera más protectora para los derechos humanos, sobre todo en los procesos penales, como dice que es tan delicado. Y bueno, muchísimas gracias. Vamos a empezar con las preguntas para el profesor Anthony Perri. ¿Cómo ha reaccionado el gremio de abogados y la ciudadanía ante la regulación de la justicia digital y la posibilidad de volver a trabajar de manera física? ¿Considera que es conveniente la unificación y mayor regulación del uso de tecnología o es preferible la descentralización y, en su caso, diversidad de prácticas de justicia digital atendiendo a las distintas problemáticas y contextos?
Thank you. Well, two of the questions related to, I believe, was the attorney reaction to the move to virtual digital court format. And I would say that New York did have a variety of reactions. That at the height of the emergency, I think all parties, all attorneys realized the necessity of adapting and of being patient. But I think then the different experiences at different times regionally of the pandemic affected how attorneys outside of New York City in more rural or further north areas wanted to get back to being in a courtroom physically much more quickly than those in the urban areas. And I think there also was a difference in how readily some attorneys wanted to utilize the technology based on age and experience in technology. But I think that also because of how the pandemic affected older age groups more acutely and those with comorbidities or other risk factors or family members they were taking care of, that the technology became more advantageous to those same groups that may have been more resistant at times. That it allowed people that had to care for children that were not in school to participate in court proceedings. That it allowed attorneys who had to care for elderly parents or their loved ones to be able to appear in court at a moment's notice, as opposed to having to travel to the downtown areas of cities. So I also think that attorneys in the criminal context and those that were more litigation, trial-focused attorneys realized that there are limitations to the digital format, especially in proceedings that require juries in the English common law system, and that the jury question was one that I don't think we ever got to a comfortable place of unwinding, to ensure that a jury was of one's peers and that technology didn't warp the pool of jurors, of only allowing the ability to serve as a juror to someone who has high-speed internet, someone who has a technological platform that would allow them to fully participate in observing the proceedings and taking in the evidence and hearing the judge's instructions and the witnesses, being able to assess their credibility, that we never did make a jump, and attorneys gave us caution, rightfully so, of moving to as some states have done, fully online trials where the jurors were also participating remotely. And that connects to the question about the greatest participation of the public in these various proceedings, civil and criminal. And I think that we really worked earnestly as a court system with the legislature and the governor to ensure that whatever technology gaps existed, and Magistrate Capizano touched on this, and it spoke to me, that the technology gap didn't translate into an excuse for a gap in access to justice. And that similarly to what was described by the magistrate, providing multiple access points for the most marginalized or self-represented litigants in civil, family, not just criminal matters, to be able to walk into a courthouse and have live help or a constantly manned telephone helpline was critical to ensuring that those people that don't know how to get online can get online and take advantage of whatever services the courthouse is a clearinghouse for. And that additionally, never allowing the digital format and the virtual format to fully replace the traditional formats, and allowing multiple access points to people that don't have other options in rural communities, in the far upstate regions of New York, but that where professionals or other governmental institutions, whether prosecutors, public defenders, law firms, and attorneys are involved, pushing those groups to fully utilize the digital format and requiring electronic filing as much as possible in those professional spheres, so that the resources necessary, especially during the pandemic, to go to those that can't take advantage of that are focused on those populations so that they are able to participate as much as possible, and that there isn't this gap that otherwise technology can result in. So that I think that is critical to getting the participation of those parties in the proceedings as much as possible. And one of the things that the magistrate did talk about were the utilizing and leveraging technology through notification, digital notification, texting, and other platforms, even through social media, to get information out and to remind individuals of required appearances, to bring them into the court system so that there aren't the collateral consequences of a failure to appear that could affect a civil or a criminal proceeding if a necessary party fails to appear. So I think that those kind of outreach steps, where the courts don't view themselves simply as a playing field, but as a backstop to ensuring that some basic level of equal justice before the law is always ensured to all parties coming before it, is necessary, and taking additional public policy steps in that respect, we have endeavored to do, and I believe is necessary in responding to emergencies, but that it only brought out pre-existing issues that were there already, that hopefully this increased attention going forward continues to bring those populations into the fold of the court system so that they can gain protection of the rights that otherwise maybe they were assuming they did not have anyone that would hear them and protect them.
Muchísimas gracias, sin duda. Claro, sí, la pandemia trajo a la luz problemas que ya existían, y muchas gracias por su perspectiva de que pues hay que tomar en cuenta a los usuarios, ¿no? Como comenta, quizá los usuarios de las zonas más alejadas tienen distintas preferencias o dificultades pues sí, preferencias adecuadas a su contexto, y esto es muy importante para generar un verdadero acceso a la justicia a partir